Hello and welcome. I'm Sanjay Pinto. The DMK, whose top brass had camped in Delhi with a fond hope of escorting Kanimozhi back home, is now probably tired of saying we'll fight it out legally. The DMK chief's daughter's fourth bail application has been dismissed. Kanimozhi's hope of leaving Tihar jail stemmed from two factors: the Supreme Court's earlier observation that she could file a fresh bail plea after the framing of charges, and secondly, the CBI's decision not to oppose her bail, unlike the previous occasions. But in a strongly worded order, the judge said he wanted to send a message to white-collared criminals. A shocked DMK team in Delhi, which went into a huddle after the verdict, has decided to do three things: not to react, to file an appeal in the Delhi High Court, and to call for a meeting of its executive committee later this month. But off camera, leaders harp on a media trial that they say has created an impression, a presumption, and perhaps even a conclusion of guilt of those accused in the 2G case. But the judge had pointed out that the order was based on principles of justice, not on external factors. We would like to make it clear that we have and always will continue to steer clear of any media trial of any sort. We will not cross the constitutional LOC and usurp the role of judges or attribute motives. But as journalists, we have a right, we have a duty to raise relevant issues, and that's what we will do in this special program. So in the light of what's being debated outside courtrooms and in the corridors of power, this is the big question tonight. Is Kanimozhi a victim of perception? Joining us live in fact, is the editor of Tughlaq Cho Ramasamy. Joining us live in the studio is A. Saravanan, a former public prosecutor, and also Asim Shehzad, a criminal lawyer, will be joining us shortly. But first, it's over to Evelyn Matthew for all the headlines. Evelyn?
Thanks very much indeed. Let's take you through the top stories we're tracking at 8 tonight. A special CBI court dismisses bail pleas of Rajya Sabha MP Kanimozhi and other accused in the 2G scam, cites the enormity and gravity of white-collar crime.
As far as the court is concerned, the court has perceived guilt even before the trial has commenced and is punishing them for a wrong which is yet to be proved.
There is shock not just within the DMK but also legal circles, the party's executive body to meet later this month. A Dalit judge of the Madras High Court levels allegations of harassment by fellow judges but doesn't name anyone just yet.
So far, I have not mentioned any brother judge's name or sister judge's name. I will disclose the brother judge's and the sister judge's name at the time of inquiry.
Major political parties in the state lash out at the state government's move to convert the Anna Library into a children's hospital. A petition against the shifting is filed in court.
Not to shift the library without first getting the views of the public, because you don't have right to shift the place of a library, working library.
A corporation bus rams into a lorry in Namakkal, 6 killed and 20 injured. The director of the nuclear power plant in Kudankulam says the recent protests by residents have caused a backlog. And the chief minister orders free distribution of sanitary napkins to young girls in villages. It's now over to Sanjay for the story that's grabbed everybody's attention and the big question on your mind.
Thank you very much, Evelyn. It's been an emotional day, one of shock, one of absolute disappointment for Karunanidhi, for his family, and for the DMK today. As a special CBI court dismissed her bail plea, an otherwise calm and composed Kanimozhi is reported to have burst into tears. A shocker for the party, even as the top brass was in the capital hoping for a final homecoming. Bail was also denied to the 7 others accused in the 2G scam, citing the gravity of the crime and the enormity of the offence. The court said public money was used for personal purposes, causing huge loss to the economy. On Kanimozhi, the judge said she belonged to the upper crust of society and was also an MP, and that by no stretch of imagination is she being discriminated against on grounds of gender. Kanimozhi has been in jail, remember, since the 20th of May, that's more than 5 months, charged with criminal conspiracy in the 2G scam. From her brother, MK Stalin, to TR Balu, top DMK leaders were in Delhi. Many of them, including Khushbu, were in the court. Kanimozhi's husband, son and mother met her in the court lockup. The DMK chief, Karunanidhi, is said to be extremely upset, and the party will move the Delhi High Court for bail. And these are the reasons given by the judge of the CBI Special Court, O.P. Saini, for the rejection of bail. And I quote, The persons involved in such offences, particularly those who continue to reap the benefits of the crime committed by them, do not deserve any indulgence. Any sympathy to them, not only being entirely misplaced, is also against the larger interest of society. The court cannot be oblivious to the fact that such offences are preceded by cool, calculated and deliberate design with an eye on personal gain. If a person knows that even after misappropriating huge public funds, he can come out on bail after spending a few months in jail, and thereafter he can continue to enjoy the ill-gotten wealth obtained by illegal means, that would only encourage many others to commit similar crimes, in the belief that even if they have spent or have to spend a few months in jail, they can lead lavish and comfortable lives thereafter, utilizing the public funds acquired by them. In fact, not everyone would mind luxurious living for their families, even if it comes at the cost of spending a few months in jail. A strong message therefore needs to be sent out to these white-collared criminals and those who are waiting in the wings, that in the long run, it does not pay to be on the wrong side of the law. The community or the state is not persona non grata whose cause may be treated with disdain. The entire legal community is aggrieved if economic offenders who ruin the economy of the state are not brought to book. Now, there's shock not just within the DMK but also in legal circles. Here's what Kanimuri's former lawyer Ram Jetmanani had to say.
What the judge has done is a serious miscarriage of justice. I believe that this judge seems to have decided that no relief should be given except by the Supreme Court itself. He is not therefore wanting to do what is plainly right. I consider it grave miscarriage of justice and on a deliberate misapplication of law. I hope the Supreme Court will soon put this right. Bail can only be denied if a person is likely to abscond or tamper with the evidence. There is no such evidence in the case of at least this moment.
All right, Ram Jetmanani there. Now, the defense lawyer for some of the accused, Aman Lekhi, also didn't hide his disappointment.
We are now joined by Mr. Aman Lekhi, lawyer for one of the accused in the case, former Telecom Secretary Siddharth Behura. Sir, you have been sounding rather angry since this order came out. You've called it an unfair, unwarranted order. One of the things that the judge has said in a very strongly worded judgment is that the ultimate objective of the accused was to use public money in a carefully planned manner for personal use, something they had no right to do. That is his reason for rejecting the bail pleas. How do you respond to that?
Perverse is how I describe it. He's jumping the gun and he's forgotten the stage at which he's making the statement. Only a charge has been framed and charge only shows the case is fit for trial. Guilt is yet to be adjudicated because the evidence is to start on the 11th. On what basis has the court concluded that they have benefited or it's a scam? That means as far as the court is concerned, the court has perceived guilt even before the trial has commenced and is punishing them for a wrong which is yet to be proved. This is not the way in which a bail proceeding is to be dealt with, and this is precisely a grievous with regard to this order. The order deals with the perception of guilt, not before the proof of it is established, and then talks about apprehension for which there is no factual basis. On both counts, the order is wrong.
Right. So now, considering that the CBI itself was not opposed to the bail pleas of at least 5 of the accused this time, and the Supreme Court had given them the liberty to approach the trial court for bail after framing of charges, what do you think went wrong? What is it that went against the accused?
Went against the 5 accused, went against all the accused.
All accused, sir, because obviously bail has been denied to all 8.
Now, so far as the concession of the CBI is concerned, the concession of the CBI shows that the CBI admits it's a case of bail. Now, once the CBI admits a case of bail, and that a case of bail, as far as the 5 is concerned, the case of conspiracy, it can't run away or fight shy of the consequences of that concession. That the bail should be granted to all. That said, no court can act only on a concession, though the concession portrays the CBI in a poor light.
You're saying it was wrong on the CBI's part to divide the accused into 2 different categories.
I mean, not only was it wrong ethically to do it, it was wrong legally to do it. And there was absolutely no answer to the CBI when we raised the specific plea of the legal consequences of this particular segregation, which are completely absent from the statutory basis of it. Now, insofar as the concession is concerned, the concession is never binding, but the making of the concession shows that as far as the CBI is concerned, it is oriented by considerations not strictly legal, because for it to actually segregate between accused shows a preference of some over the others, which doesn't go an unbiased and fair investigating agency.
So you've hinted at political intrusion in the past.
No, whether it is political intrusion or not, you see, the question is that in a high-profile matter like this, you should be averse to doing anything which is suspect in any manner whatsoever. And it defies sense that how in the case of conspiracy, you can actually subdivide the accused into two groups, which is something which does not make sense. But what our case was, that independent of the concession, whether there is a concession or not, the peculiar circumstance of the case makes it a fit case of bail. Unfortunately, the court hasn't dealt with the latter aspect, and it has in fact proceeded to reject it on a perceived assessment of guilt, which I feel is premature.
So now you've been saying the accused here are all victims of perception. Do you feel that they're still behind bars because they're all high-profile people in a high-profile scam case?
Absolutely. You see, the schadenfreude is what the word most appropriate for it. People feel happy in a case like this, helpless and frustrated to find some in the dock and want to continue that also. Because of the hype which is being created around this case, the figures which are being bandied about, and the general perception the wrong has in fact happened, it is not something even the best of judges will be immune from. And this is where I personally think the exercise of discretion will some way be affected, because of the apprehension about what an order which is otherwise justified in law may be perceived by the lay people as. Now, the perception of the lay people is not going to be something in which the rights of an accused can actually be jeopardized.
Sir, you're talking about public perception, but surely the judge cannot be accused of playing to the gallery. He has gone by the law.
No, the judge is not playing to the gallery, but the judge has yet not gone by the law, because had the judge been gone by the law, the judge would not have pronounced upon the guilt at the time when he is deciding bail, before his commenced trial, and proceeded on an apprehension for which there is no factual basis. He may not be proceeding to playing to the gallery, but yet he is completely wrong in law, and the order is wholly unjustified in the facts.
So finally, you're moving the High Court, but what hope do you have of getting this fight from there?
I only hope we get a robust court which is not deflected from the legal principles, which legal principles unimpeachably scream out for some relief to these accused, because in the circumstance of this particular case, with you hounding everyone where the scam is concerned, the country focusing its attention on the details of this particular case, the accused being the high profile accused that they are, not someone who can actually be secreted away or can abscond. The trial proceeding day to day, when they will be forced to come, why keep them in custody?
Right.
Right, quite an upset lawyer there. Now, the DMK has called for a meeting of its executive committee later this month, as we said earlier, but the Congress says the court development will have no bearing on the party's ties with its ally, the DMK.
Well, I don't think it has anything to do with the DMK or the Congress party per se. Here is a matter which was investigated by the Central Bureau of Investigation on the pursuance of the Supreme Court. There is a charge sheet which has been filed. The matter is being considered by the trial courts, and I don't think that the merits of a particular decision should really be extrapolated to play up or play down upon the political relationship between two political parties.
And joining us in the studio is A. Saravanan, former public prosecutor. Saravanan, thank you for joining us. And also Asim Shehzad, the well-known criminal lawyer in Chennai and partner of BFS Legal. Thank you, Asim, for joining us. To you first, when the fundamental canon of criminal jurisprudence is that bail is a norm and jail is the exception, why do you think it's so difficult for Kanimuri to get bail? This is a fourth application that has been dismissed.
Sanjay, first and foremost, right to bail is a discretionary right vested with the court. Most importantly, what the judge has done with this above judgment is that he has followed what Justice Krishna Iyer has said, that India's tries with social justice can be possible only if white-collar criminals are brought to book and held accountable.
That's what even the judge has said today. In fact, he's quoted that in his judgment.
Right. This was a 1978 Supreme Court, which was subsequently followed by a 1982 Supreme Court judgment.
Now, Saravanan, again, this upper crust argument. Now, are the courts today, do they run the risk of actually being slightly, prejudiced towards those who are perhaps rich and influential? Because if you look at even in the day-to-day practice of law, like in criminal law, the way it operates, somebody who drives a BMW goes and mows down people sleeping on a pavement and is slapped with a 304 IPC thing, that's a culpable homicide not amounting to murder. There's a big hue and cry raised if he's not slapped with the charge of murder.
That's right.
But if a state transport bus driver in any part of the country mows down another 10 people, and if he's got a mere 304A case, that is, a rash and negligent act for which you can even pay a fine and get away, then nobody really bothers. On the one hand, yes, there's no denying the fact that the poor people in the country don't really get legal recourse, even legal aid is not extended to them. Again, when it comes to the rich and famous, they spend crores of rupees on lawyers' fees, and yet in this case, they don't seem to have got relief. Why do you think this is happening?
That's what now coming to this case, they have said that upper echelons, that Kanimozhi belongs to upper echelon of the society, therefore she does not deserve to be granted bail because she is a woman. But that argument cannot be accepted, because the CRPC does not say that if a woman belongs to the upper crust of the society, bail cannot be given to her.
It just says woman, it doesn't say.
Yeah, it doesn't say, that's what it says, women. It does not differentiate between a woman belonging to the upper crust and the lower crust.
Asim, I mean that again in the court also.
There is a distinction there. If you look at CRPC 438, it clearly mentions that when it confronts with an offence which is punishable by death or life imprisonment, it's a discretion with the court. The court has exercised its discretion. Now, whether it is right or not, and whether the court is vindicated in its stance of not granting bail, can be tested only with the final verdict of the Supreme Court.
No, but the fact here is the Supreme Court had, when she last went seeking bail, had told Kanimozhi, it observed in open court, that it was open to her to go and seek bail, invoking section 437, which allows for concession for women, for people under 16 years of age, for those who are sick or those who are infirm, to go back to the trial court and seek bail after the framing of charges.
Right.
So charges have been framed. Why do you think this has happened now?
Supreme Court on the same hand has asked the CBI to explain why they have not opposed the bail application filed by Kanimozhi.
The Supreme Court has clarified that the trial judge will go on with the case without uninfluenced by what has happened in the Supreme Court.
It's one thing to say that, but in the practice of
exactly.
it's one thing for a higher court to say don't be influenced.
When media reports each and every word and distorts, gives a different meaning to what the judges say, this is bound to happen.
When you say media, you should say not Ndtv-Hindu.
Okay.
All right, let's also cross over to Mr. Cho Ramasamy, who's the editor of Tughlaq and renowned political commentator. Mr. Ramasamy, thank you, sir, for joining us. Do you believe that Kanimozhi has every reason to feel disheartened and disappointed? Does she actually deserve to be in jail for more than 5 months now?
You see, I can't say whether somebody deserves to be in jail or not. That has to be ultimately decided by the courts. But if the court suspects that an accused is capable of influencing witnesses, then they don't grant bail. That must have been the case here.
All right. Saravanan, in this case, Kanimozhi earlier told the court that she was willing to abide by any conditions. In fact, there was some talk that maybe the judge, if he had granted bail, would have asked her not to leave Delhi.
Yeah.
Also, she said she is willing to be, have jammers installed at her residence, subject herself to even the harshest bail conditions. But here, of course, this thing of tampering with evidence.
Tampering is witness. It's presumptive, Sanjay. When a person who is well capable of talking about tampering the witness is the prosecution. Here, the CBI prosecutor comes to the court and says that he has no objection in releasing these persons, and he says there is no fear of tampering with the witness. When such a statement is made by the prosecution before the court has to believe this and pass an order.
Asim, do you buy that?
Partly. The way I would look at it is, if somebody who belongs to the higher echelons of the society is incarcerated in prison, what happens is there are more likely that the person can use his or her influence to influence or intimidate the witness or tamper with the evidence.
No, for that you don't have to be outside. With the communication,
that's the point,
with
which
whatever
is what
it is,
I partly agree with Saravanan. You can very much be in the jail and you can still do it.
The point is, what influence are we talking about? The party is no longer on power here. The party is on a slippery slope with the Congress. So what influence are we talking about?
No, you are forgetting, Sanjay, that she is a member of parliament. She is still a member of parliament. She is part of the ruling alliance, and she is being alleged to have been involved in a 214 crore kickback. There are serious allegations. Whether it's true or not, eventually the court will decide.
There's no denying the fact. The allegations are serious.
When you're talking about tampering of evidence and witnesses, the investigation in this case, the occurrence had taken place in 2007. From 2007, now we are in 2011. The investigation is started from 2009. So long the CBI has said that there was no allegation.
No, but she was interrogated by the CBI only recently.
Yeah, that's what. But FIR was registered as early as 2009. From then on, there was not even a whisper that evidence was tampered. It was nobody's case that they attempted to
Okay,
tamper.
and also now you're saying
investigation.
the CBI has not felt apprehended any tampering of evidence. Asim, to bring you in here, most of the evidence regards this alleged 214 crore rupee kickback pertains to its documentary evidence, which has already been collected by the CBI. Right. Where's the question of evidence? Where do witnesses come into play now at this stage?
The most important thing that from a court's perspective, why it was not inclined to grant bail to Kanimuri is what we are debating here in the studio. Now, from the court's perspective, the court was dealing with a person who is politically aligned, who has political connections, and whose alleged acts have caused loss to the exchequer to the tune of several crores. Here, if a lower court grants a bail, more likely than not, there are fingers are going to be pointed to the judge.
But if the lower court had granted bail, it is very unlikely that the CBI would appeal because the CBI had not opposed the.
No, that's what CBI has made it stand very clear that these persons are placed differently apart from the main accused persons. Therefore, they can be treated. They have to be treated differently, and bail has to be granted.
Again, that was an important point that was raised by Ram Jethmalani himself. Although he had argued the bail plea of Kanimuri earlier, unsuccessfully though, in the trial court in the first instance, saying that why are you adopting double standards? Why is the CBI not opposing bail of some accused, and why is the CBI opposing the bail of some of the corporate head honchos, which is what a battery of lawyers told the Supreme Court, which prompted the Supreme Court to ask the CBI as to why they have actually done this, right? So when it comes to the question of parity here, Kanimuri is the only woman who is behind bars.
Exactly. See, that's what, as I pointed out earlier, the Supreme Court itself has pointed out when during the bail application in the Supreme Court, they said she has to be granted the relief of bail because she's a woman. Supreme Court said, yes, you go approach the trial court after framing of charges, and you also raise the point that you are a woman and satisfy the trial judge.
It's a discretion of the court.
No, it's not the discretion. See, discretion, yes, it is a discretion of the court, but the law mandates, the statute mandates that a consideration has to be given because she's a woman.
There is not a single judgment of either the High Court or the Supreme Court which lays down the conditions or circumstances in which bail can be granted. In such a situation where there is huge public outcry against the corruption which is on a large scale, there is media now which is propagating or inciting masses, I would say. Some of the
inciting,
media.
I don't think they're inciting.
No, because see, with the Anna Hazare campaign, what is happening is there is a trend of anti-corruption throughout the country. With this involved,
let me bring in Cho Ramasamy here. Sir, now does one get the impression, because Ram Jethmalani recently said in an interview that judges are perhaps playing to the gallery when it comes to bail. Do you buy that?
Well, I won't say that they are doing that. Why not? Even Ram Jethmalani is highly capable of it. He is a very good friend of mine. When he decides to play to the gallery, he does it as well as anybody else, or perhaps better than anybody else. So I wouldn't accuse the courts of doing that. And the galleries, I don't think, are that much interested in keeping Kanimuri or anybody else in jail.
All right. Mr. Ramasamy, also the Supreme Court, as I was asking Saravanan here in our studio, had asked Kanimuri to go back to the trial court after the framing of charges and invoke that particular section 437 of the CRPC, which allows that concession for women. Why hasn't that been shown to Kanimuri in this case, is what many of our party workers want to know.
Well, the law, even in the courts, will have some consideration where the accused are women. But where they are highly influential, the court has to guard itself and the procedure against any miscarriage.
All right, the Supreme Court also asked the CBI why it had not opposed the bail of the 5 accused, including Kanimuri, and opposed bail for the corporate head honchos. Was that probably a reason that weighed on the judge's mind, which is why it made him sort of reject Kanimuri's bail plea?
No, I don't think so at all. I don't think he would have been influenced by that, because these questions are put by courts to elicit the opinion of the concerned parties, and it doesn't mean that the court feels like that. So I don't think it was any direction to any lower court that was issued by the Supreme Court.
All right, at a political level, Mr. Ramasamy, do you see the DMK perhaps pulling out of the UPA at this stage?
No, I don't think they can afford to do it. They are in a very shaky wicket here, and they have fared badly in the local body elections also. And they would not like to face Jayalalitha without having a share in the power at the centre. So I don't think they would antagonize the Congress totally. They may make some kind of a gesture, maybe, but they won't break off relations with the center.
All right, one final question to you, sir, before we let you go. How do you think this will play out in the DMK first family? Will the various one power center hit out of the others? Because there have been rumblings within the DMK that, you know, she's got 20% stake and others have got more. So why is she in and others out?
People will be driven to think that I will blurt out everything that I know. Somebody may start doing that. I don't know.
All right. Thank you very much, Mr. Namasan, for joining us. We're completely running out of time, but very briefly, how do you view Kanimuri's chances for bail in the High Court, the Delhi High Court?
Yeah, High Court, I think she has to get it in the High Court, Sanjay, because bail is granted only on two conditions: whether you know they will flee out from justice, and whether they will be tampering the witnesses. When CBI has made it clear that they have not tampered witnesses so far, and there is no possibility, as you put it rightly, that all evidences are documentary evidences. So there is no question of going.
Is that the case?
Yeah,
okay.
Yeah. Most of the witnesses, most of the documents.
But they had said earlier that some of the witnesses could also be employees of Kalina TV.
No.
Okay.
Most of the evidence in this case are documentary evidences. When that is the case, where is the question of influencing or tampering? So far, they have not done that. From 2007 to 2009, they have not tampered with any documents. That is why CBI has got those documents. So there is no question of tampering with the witness, and there is no question of fleeing away from justice. When these two grounds are satisfied, bail has to be granted.
Earlier, the judge said that she was the active brain.
No, that
and
is
this entire thing of this loan was actually a smoke screen for a bribe. That's what the judge said in the court.
That may be the allegation. That may be the allegation. But for consideration of a bail, all these things should not play into the mind of the judge.
Okay.
Ultimately, this is only after the trial, when she has been given an opportunity to prove her innocence. Then only all these things can be discussed in a bail application.
How long do you think, Asim, how long will this will the process take for this bail application be filed in the Delhi High Court and also for it to be resolved?
Once the order copy is made available, bail will be preferred immediately. In such circumstances, the application could even be moved on Monday, as early as Monday. But taking cue from what Saravanan was mentioning about the charges leveled against her, if from 2007 there were no allegations of tampering, etc., the only question that I want to ask Saravanan is, why was the CBI opposing the bail all along, and all of a sudden it gave up opposing?
That's valid.
Exactly. See, all along, while the first bail application came up, it was on a legal point. Legal point in the sense, it was argued on behalf of Kanimuri that after investigation, she need not be arrested. Arrest is only at the time of investigation. After investigation, when charge sheet has been filed, there is no need for arrest, and they said she has to be released when she has been asked to appear on summons, not on any warrant. As a dutiful citizen obeying the court summons, she appeared before the court and surrendered herself to the jurisdiction of the court. So there was this legal argument whether the court can remand the person who has appeared on summons. Normally in courts, normally in Chennai, in all other places, what happens is when somebody appears on summons, they will receive the sureties from them and let them out on bail immediately on the same day. So that was the legal point, and that was even in the Supreme Court, that was the point which was raised, which is yet to be resolved. So during that time, CBI opposed it, but now even all the other investigations are completed, and taking into account the fact that the role played by her, even alleged by the CBI, is very limited, they have said that she can be released on bail.
All right.
If it was limited to that, why would the Supreme Court make an observation to the effect why CBI did not oppose?
Supreme Court said don't be influenced by what we said. Supreme Court clarified to the satisfaction, the additional Solicitor General satisfied the Supreme Court about why they were not able to oppose
this debate can go on and on. I'm sure the next debate will take place in the court hall there in the Delhi High Court. But thank you very much, gentlemen, for joining us and giving us your perspective. And just to tell you, your ride back home will be much costlier, because we're getting news that in fact petrol prices have gone up by about ₹1.80. So you'll have to pay a little more to reach home. But that's all the time we have on this bulletin. Thank you very much for joining us. But stay tuned. Coming up next is Tamil News with Nirmala Raman.